of your classmates who couldn't be here, who may want to watch it later. This is our last live session in real time. This is module 5 in a 5.5-week course. It's hard to believe, Alyssa, that it's almost over. It will end on Tuesday, August 9th. So your assignments for module 5 will be due Sunday, August 7th. And then you'll only have like 2 days to do your work for module 6. So that's how we don't have time for a live session in module 6. Instead, I will post a pre-recorded video, maybe from last term, or maybe I'll make a new one, but it will be pre-recorded. It'll contain a quiz review for module 6. So yeah. So this week we were talking about contracts in the electronic age, getting here into the 21st century. We're already 22 years into the 21st century. Hard for me because I was alive in the last century. And not only that, I was alive in the last millennium. And now we're 22 years into this millennium. So it's amazing how technology has changed the way that we do business and the way that we contract, especially. So in this live discussion, we're going to talk about the research requirements to form a contract remotely. Now that people are forming contracts via email, websites, forming contracts on your phone with Amazon. We're going to look at choosing clear and effective clauses to exclude warranties. We're going to view illegality. We're going to research incapacity and undue influence, assess fraudulent contracts, and judge the ethics of working with incapacitated persons. Let's first talk about unenforceable agreements. So a contract must have offer, acceptance, and consideration. Alyssa, that makes a contract. But in order for a contract to be enforced, both individuals must have the mental capacity to contract. Also, what do you think would stop someone from having the capacity to contract?
Under the influence of any type of alcohol, intoxication, drugs.
Exactly. Another thing would be someone who is has Alzheimer's disease or is mentally incapable, or someone who is under the age of majority. Minors may lack the capacity to contract. You know, if a 15-year-old inherits money from his grandfather, that doesn't mean that he can enter into a contract to buy a $100,000 Corvette. That contract would be voidable by the minor's parents. So usually when a contract is voidable, it can be voided by the person who lacked the capacity to contract. The other party would still be required to uphold their end of the bargain. The person who can void it is the one who lacks the mental capacity to contract. So the infancy doctrine would cover minors. Let's talk more about capacity to contract. The law presumes that parties to a contract have the requisite contractual capacity to enter into the contract. Certain persons lack this capacity, including minors, insane persons, and intoxicated persons. The common law of contracts and many state statutes protect persons who lack contractual capacity from having contracts enforced against them. The party asserting incapacity or the party's guardian, conservator, or their legal representative would bear the burden of proof of proving lack of capacity. Let's look at insanity. Some people have been adjudged, determined by a lawyer to be mentally insane. If someone has been determined by a lawyer to be mentally insane, not only should they not be buying firearms, they shouldn't be contracting, period. So in that instance, the contract is completely void. It is illegal if the person has been adjudged insane. That means determined in a court of law to be insane by a judge. Nobody can enforce that contract. It is void. However, if you're dealing with someone who is insane, but a court has not made a judicial determination on sanity, Hi, Nicole. That contract would be voidable by the insane person or their guardian. The competent person, however, cannot void the contract. So that's usually the rule. When you're dealing with an unenforceable contract, the person who has the mental capacity can't get away from the contract. It's only the crazy person who can escape the contract, or the person who is under the age or intoxicated. Let's talk about intoxication. Most states provide that contracts entered into intoxicated persons, again, voidable by that person, maybe because of drugs or alcohol, it could even be prescription drugs. The contract, however, is not voidable by the party who was sober and had the capacity to contract. They're on the hook. The only time they're not on the hook is when the contract is completely illegal. So let's talk about legality. One of the requirements of an enforceable contract is that the object of the contract must be lawful. Most individuals and businesses do enter into legal agreements that would be enforceable. Contracts for the sale of goods, services, real property, intellectual property, buying and selling software licensing agreements. For example, the Microsoft Word and the Microsoft Suite Office that we use on our computers is licensed. Bill Gates and Microsoft own that software. They own Windows. We license it, pay a licensing fee to have that on our computers. Sometimes our employer or our educational institution or the university pays the licensing fee, but us using Microsoft PowerPoint, Microsoft Word is through a licensing agreement. That's an enforceable contract. That's a licensing agreement for intellectual property because Microsoft Word is copyrighted and patented. You know, a lot of software is copyrighted and patented. Some contracts do have an illegal purpose or an illegal object. A contract with an illegal purpose would be void. I think selling gambling machines in a state where gambling is illegal would probably be void. Selling lottery tickets in a state where the lottery is illegal, like Nevada. I guess the lottery is $2 billion. Has anyone bought lottery tickets lately? The last time I bought a lottery ticket is when I was in Arizona. Arizona is only an hour and a half away. But here in Nevada, the lottery is illegal. So we cannot purchase a lottery ticket. It's illegal in Alabama also. I'm not sure where else it's illegal. It may be illegal in Utah. But I actually have some scratch and win tickets here that I bought in Arizona. I haven't been able to cash them in because I haven't been back to Arizona, and the lottery is illegal here in Nevada. So, um, again, a contract for murder, a contract to murder your spouse. It seems to be happening more and more these days, although it's been something throughout history. People get tired of their spouse. They want to get a new mate and they kill their spouse. If you've ever watched any criminal reenactments, it's on there all the time. Forensic Files, any criminal reenactment, people are, they're trying to hire someone to kill their spouse. Contracts for hire to commit murder, solicitation for murder is illegal. You're not going to be able to enforce a contract like that unless you can get somebody in the mafia to do it. It will not be enforced in a court of law. Um, a contract that's usurious. That would be a contract for a loan at an interest rate that is illegal. A very high interest rate would be a usurious agreement. So anytime you have a contract with a high interest rate, that would be illegal. State law determines the limit on how much lenders can charge for certain loans. Like a lot of times payday loans are under scrutiny as being unconscionable, as being completely unfair for consumers, and for being usurious because of the amount of interest that is charged over time. Can you think of any other contracts that would be illegal? Nicole, what would be an illegal contract? An example of an illegal contract.
Promising, no. Maybe
Think,
promising a good for one thing, and then when you get it, it's not what you thought it was. I'm trying to think of a.
yeah, that would certainly fall under a consumer protection law. How about drugs? How about cocaine?
Yeah, that would be definitely illegal.
How do people get cocaine, Nicole?
Your neighborhood pharmaceutical guy on the corner. You got to hook
Right.
up from somebody that can give it to you, or um, the doctor. If a doctor is selling it, doctor is selling drugs. Get it that
Okay,
way.
that would all be illegal. So a contract for the sale of drugs is illegal so long as that it's illegal in that state. In Nevada, marijuana is legal, although you still have to purchase it in a state authorized approved dispensary. So I do not believe that it is legal to purchase marijuana on the street. It needs to be purchased in an authorized state dispensary. So a contract for the sale of drugs is illegal. You can't go into court and say, Your Honor, he didn't deliver the cocaine, because you're going to get arrested, and so is the person that you're accusing of selling the drugs. So that's a contract with an illegal purpose. So contracts to perform activities that are prohibited by law are illegal contracts. Usury, agreements to commit a crime, contracts to violate public policy. I think they would also cover prostitution. There are maybe one or two counties in America that may still allow prostitution, but any contract like that in a place where it is illegal, which is the most places, that would be an illegal bargain. And that's why when you're watching crime TV, or crime dramas, you see prostitutes, people getting arrested. People trying to purchase their services might also be arrested, because that is an illegal activity, and contracting for it is also illegal. Exchanging money for that's an illegal bargain. Someone is going to get arrested if the authorities are notified. Let's talk about special licensing statutes. All states have licensing statutes that require members of certain professions to be licensed by the state in which they practice. Problems arise if an unlicensed person tries to collect payment for services provided to another under a contract. An example of this is unlicensed contractors. If a contractor gets hired to work on a construction project, develop a mall, build some real estate, and then after the contract's been performed, if that unlicensed contractor tries to sue, the court has closed its doors to that lawsuit because the contractor lacks the license that the state requires. So if an unlicensed person tries to collect payment for services provided under the contract, they will not be able to use a court of law to do that because they don't lack a license. Doctors practicing without a license, dentists practicing without a license, that's all illegal. Another type of illegal contract would be, in certain instances, if you get hired to work a certain job, you may be required to sign a non-competition agreement saying that you will not compete for your employer's clients in that same industry. So this happens often in the healthcare industry. For example, if someone gets hired to work for a medical practice, and they may need to sign a non-competition agreement that says they're not going to leave that medical practice and start up a new solo practitioner family practice office across the street and try to compete with those same patients. Now, under certain circumstances, if a court says that that is a restraint of trade or that interferes with someone's right to work, then that non-competition agreement would be unenforceable. Any questions about unenforceable and illegal contracts? Unconscionability. Some contracts are so unfair that they shock the public conscience. Generally, in America, our forefathers had the wisdom to put freedom of contract in the Constitution. In fact, the Constitution says, no state shall impair the obligation of contract. So there is a contractual right spelled out in the Constitution. It is not inferred. It was not interpreted. It's in black and white. The Supreme Court will never be able to overturn that. So there's a general freedom to contract. So long as the object of the contract is lawful and the elements for the formation of a contract are met, the court will enforce a contract according to its terms. However, some contracts are so oppressive or manifestly unfair to the consumer that they shock the public conscience. They're unconscionable or unfair. One would be tiny printed form contracts that a consumer signs. I think an installment contract with a balloon payment, waiver of liability for a tort injury, waiver of the right to sue. Sometimes businesses will put disclaimers in tiny print where you're waiving your right to bring a lawsuit, waiving and disclaiming warranties, taking advantage of consumers. There was a case I recently read where a consumer purchased a product and at the point of sale, there was a waiver of the right to bring a lawsuit and requiring only arbitration of any disagreement. Well, the person was blind. So when they inserted their chip and did their card, they were not able to see the fact that they were waiving their right to bring a lawsuit based on the defect in the product. So the court said that's unconscionable. That won't be enforced. Any questions? Okay, have any of you entered into an e-contract this week? Anyone done any contracting on the internet?
Yes, I have.
Would you mind telling us what you bought?
Some clothes for a trip.
Excellent, excellent. Did you reserve any hotel accommodations or a flight or anything like that online?
Yep. Yes, I did.
Excellent. So yeah, that's all e-commerce, Nicole. Buying and selling goods on the internet is e-commerce. The UCC wants to encourage, again, the free flow of commerce because it's vital to our economy. And since the pandemic, the use of e-commerce has absolutely exploded. Really, you know, around the turn of the century, around the 2000s, is when Amazon really started taking off. In the 1990s, Jeff Bezos was just a guy in his garage with a little tiny old-fashioned desktop computer and a word Amazon scribbled on a piece of paper. He just had a vision and a dream about a company. But right around, again, the turn of the century, Amazon started, e-commerce exploded. And now contracts can be created online. They can even be created via email. E-contracts are electronically made agreements that are just as enforceable as any ordinary oral or written contract. They don't even need an electronic signature. One of the challenges, though, is figuring out what are the terms of the agreement and, you know, who are you contracting with? Consumers may not even know the actual seller, since many purchases online from a business are made through a larger company's website. So if you buy something on eBay, you're not buying it from eBay. You're buying it from an individual seller who lists on eBay. Same thing with Amazon, same thing with Walmart. I recently bought an air conditioner online at Walmart because my air conditioner in my house was broken. So, you know, I was waiting for the repairman to come over I was like, I'm just going to buy an air conditioner on Walmart. Well, now I'm ready to return it because my central air is working again. The problem is that the seller is not Walmart. It's a private company who lists on Walmart. So it's going to take some extra hoops for me to return that air conditioner. So the consumer may not even know the seller and may not understand all the terms of the agreement, like how long do you have to return the item? What are the warranties? Can you bring a small claims court suit if the item you purchase is defective? It's sometimes very difficult to determine what those terms are. Let's talk about warranties. A warranty is a promise that a product is fit and will be repaired if it is not fit. Sellers and merchants offer warranties. The express warranty means that the label of the product should say what it is. The product should be what the seller says it is. That's an express warranty. The seller says you are purchasing an automobile, a four-door sedan. That's an express warranty. And the law will imply certain things that that car is fit for ordinary use. It is fit to go on the road, for interstate travel, for travel to and from work. It's an implied warranty of fitness. That's also known as the implied warranty of merchantability. If you buy a blender, there is an implied warranty of merchantability, which means that the seller guarantees that the product does what a product of its type will normally do. If not, it fails the warranty. So if I buy a blender, I can expect that blender will work. Not that it will blow up when I put a banana in it. Okay. If it does that, I have a products liability lawsuit. Let's talk about the implied warranty of fitness for a specific purpose. The seller has reasons to know and understands the purpose that the person is buying it for. When the seller and the buyer are both businesses, a new contract is made specifying the purpose. So implied warranty of fitness for a particular purpose. If I go purchase, say, a rider mower, and I tell the people, look, I'm going to be using this to, mow my lawn, and it's really, I've got thick grass, and I've got some shrubs, and I've got weeds, and I've got this, and I've got that. And if there's a special circumstance and the seller has reason to know that the buyer's using it in a special situation, then there's an implied warranty of fitness for that specific purpose that the buyer is buying the product for, so long as the seller knows what that is. So these warranties are very, very important. And that is something that will be on your quiz. Exclusion of warranties. It's a myth that businesses add warranties. They customarily will try to limit the warranties. This is because warranties are already set by state law. The standards one set by law can, in some instances, be limited or excluded unless the limitation is prohibited by consumer protection laws. Businesses are trying to, of course, get out of any liability, and they're trying to get out of warranties. So a business may exclude the warranty of merchantability. However, that's implied at law. So here we go, UCC 2-316 requires that any exclusion of the warranty of merchantability has to be conspicuous, bold, in caps, with large typeface. Otherwise, if the exclusion isn't really big, then the consumer is not going to be expected to see it. And their merchants and sellers are required to avoid fine print when they're trying to exclude and disclaim warranties. That's New Jersey Statute 12A 2-316, which is the New Jersey version of the UCC 2-316. So take the time to complete the knowledge checks on warranties that is found within Module 5. Let's talk about your written assignment for this week. The quiz is in Module 6. This week you've got a written assignment. Johann and Mary are helping their grandfather who has dementia. They want to receive his assets, but they are aware that that they may be accused of elder abuse. So they have asked an attorney, your supervising attorney at the firm where you work, to prepare a contract for Jacob to sign. They will normally do weekly housekeeping and look in on Jacob 3 times a week and return for the remaining funds payable over a 3-year period. They will not do any personal care, but they will arrange for the care of Jacob as needed. They will each receive a salary each month from Jacob's Social Security and his 401k. And they will also get another $50,000 at the end of each year. If their grandfather should outlive his assets, his grandchildren plan for him to go on Medicaid and assisted living at the state's expense. Alyssa, does this sound ethical to you?
No.
Not. Sounds fishy.
I don't know how to describe it, but it does.
What does the grandfather have? It's in that first sentence. What is the grandfather suffering from?
Dementia.
Does he have the capacity to contract?
No.
Maybe not, right? He hasn't been adjudged to be, a ward of the court. There hasn't been a guardian appointed for him yet, but he may lack the capacity to contract. So would it be ethical for an attorney to write up a contract like this, knowing that the grandfather has dementia?
No.
So that's an issue. It's definitely an issue. So your written assignment says, find the latest and most recent case that you can in Lexis Advance or Fast Case in any state using a search, quote unquote, voidable contracts and incapacity. The first 2 words are in a quote to make sure that the search finds cases that include those 2 as a phrase. So you're going to search for the quote unquote phrase voidable contract. You can just type and incapacity. So you want to find a case on the topic of avoidable contract due to the lack of capacity. You're going to then find and cite the most recent case in any state on contract law and undue influence. You want to, again, put the words undue influence in quotes, use an ampersand and contract, and then not crim with an asterisk. You do not want a criminal law case. Criminal law action is something brought by the government or the people against a criminal defendant with the consequences being incarceration. That's not what we're dealing here with. This is a civil case between private parties where money damages might be at issue. So we're looking for a civil case, a contract law case on undue influence. Take a position on the legal and ethical questions presented in the scenario. Here are the 2 issues that you'll be required to IRAC. 1, is fraud or incapacity involved? That's your issue. You'll find the rule from your cases. You'll do an analysis of the rule with our scenario here involving Mary and Johann. And then you'll reach a conclusion about whether fraud or incapacity is involved in this contract with their grandfather. The second one is if the attorney creates the contract and no lawyer reviews it for Jacob, is that unethical under the ABA model rules? And you'll IRAC that. Complete the IRAC analysis for both issues. Use and cite the module reading, the ABA rules of professional conduct. Use your own moral compass, your own thoughts. If you need to, create a table. Please use the memorandum format, answer those questions in order. Last but not least, number 7, identify what the other side may argue. If you're going to argue that Jacob lacks the capacity to contract, see what the other side may say. Be prepared for their argument so you can respond to it. The other side may argue, hey, he's never been adjudicated insane. He's never been declared to need a conservator or a guardian. Jacob has mild dementia, but he otherwise has the capacity to contract. That's what the other side may say. So you want to be ready to respond to that. So number 7, identify the ideas on what the other side may say in response. Any questions about your Module 5 written assignment? Go in order. That's the best way to write it. 2 IRACs. IRAC, the first issue, is fraud or incapacity involved? IRAC, the second issue, is it unethical for the attorney to write up this agreement without Jacob having a lawyer? Any questions? Okay, let me give you your end of term reminders. Your Module 5 written assignment is due Sunday, August 7th. Your live session question for this week is, what is the implied warranty of merchantability? You can get it right from this lecture. You can also get it off of Google. Just be sure to submit that answer to the live session question in order to get credit for the live session. Just a reminder, Module 6 begins on Monday and ends on Tuesday. The live session video will be pre-recorded and will include a quiz review. I will release that live session video on Sunday. It's been a wonderful term. I've enjoyed getting to know all of you. Summer term 1 will end on Tuesday, August 9th. No assignments can be accepted for a grade after the term ends. And I have a question from Isabel. Yes, Isabel.
Yeah, so I was just wondering, just to clarify, are we doing IRAC for justice scenario and finding the cases, like defining 2 cases to back it up, pretty much?
Yes.
Okay.
But this time you will not IRAC the cases. You will IRAC the issue. The first issue is fraud or incapacity involved in our scenario with Mary, Johan, and Jacob? Is fraud or incapacity involved with their attempt to get his money to look in on him getting $50,000 a year plus a salary from his 401k and his savings? Would there be any fraud or incapacity involved in creating an agreement like that? IRAC that issue, focusing on the rule that you'll be retrieving from a case, the analysis, and the conclusion for our scenario. The second IRAC is number 4. If the attorney does the contract and no lawyer reviews it for Jacob, he's the grandfather, is that unethical? What's the rule? You'll need to find the rule, which would apply to entering into a contract if someone lacks an attorney and lacks the mental capacity. What would the attorney's obligation be? Find the relevant ABA rule, and then analyze the scenario and reach a conclusion. So 2 separate IRACs focused on these 2 issues. Any more questions?
I think I'm good. Thank you for answering the question.
You're welcome. Just doing my job. And any other questions, Alyssa or Nicole? Thank you all for attending the Module 5 live session. This is our last live session in real time. Module 6 live session will be pre-recorded. So be sure to submit the correct answer to the Module 5 live session question, which is, what is the implied warranty of merchantability? Thank you so much, everyone. Have a productive weekend. I'll see you in cyberspace. You're welcome,
Thank you. Have a
Alyssa.
good-
Thank you, you too.
Thanks, Nicole. Thanks, Isabel. Bye.
Bye.
Bye.